February 1993, two United States Customs agents drove from San Jose to Boulder, Colorado, to visit a software developer named Phil Zimmermann. They told him they wanted to talk about his program. Zimmermann assumed they needed advice. Then they told him he was being investigated for illegally exporting a weapon. The weapon was software. The charge carried 5 years in federal prison. Phil Zimmermann had not shipped anything. He had not sold anything. He had written a program called Pretty Good Privacy, PGP, that allowed ordinary people to encrypt their private communications, and he had made it free. In 1991, PGP found its way onto the internet. It spread. By 1993, people in Eastern Europe were using it to protect dissident communications from their own governments. A man in Latvia wrote to Zimmermann directly. He said, "Phil, I wish you to know, let it never be. But if dictatorship takes over Russia, your PGP is widespread from the Baltic to the Far East and will help democratic people if necessary." The United States government's response to this was to open a criminal investigation, because under the Arms Export Control Act, cryptographic software was classified as a munition, the same legal category as missiles, mortars, and machine guns. Zimmermann was accused of being an arms dealer because he had written a privacy tool, and it had left the country. The investigation ran for 3 years. Zimmermann was detained at Dulles Airport, returning from Hungary and Romania. His legal defense consumed years of his life and hundreds of thousands of dollars in donated funds. His lawyers would not allow him to tell the truth about why he wrote PGP, that it was a human rights project, because admitting he wanted it exported would help the prosecution prove intent. No charges were ever filed. In January 1996, the case was closed, and by 2000, the United States government had abandoned its export controls on strong encryption entirely. The technology had spread too far. The controls had accomplished nothing, except to nearly imprison a man for writing software that protected human rights. That was 30 years ago. On June 12, 2026, at 5:21 in the afternoon, the Commerce Department gave Anthropic 90 minutes to shut down its two most powerful AI models, globally, with no advance notice and no specific explanation. The directive, issued under the Bureau of Industry and Security, ordered Anthropic to suspend all access to Claude Fable 5 and Mythos 5 for any foreign national anywhere on the planet, including Anthropic's own foreign national employees. Because Anthropic cannot reliably distinguish foreign nationals from United States persons across hundreds of millions of users in real time, the practical result was a hard global shutoff. Every user, every country, gone. The legal basis was the same framework used against Phil Zimmermann. Export controls applied not to a physical weapon, not to hardware, not to chips, but to the output of a conversation, a response to a chatbot. The government's position was that Claude Mythos, when asked to analyze and fix software vulnerabilities, was effectively exporting a weapon-grade capability to adversaries. One official stated that export controls were intended to be a last resort. Anthropic said they were given 90 minutes to comply. The government had also threatened separately to invoke the Korean War-era Defense Production Act to compel Anthropic to allow its models to be used for, in the Pentagon's framing, all lawful purposes, a phrase Anthropic had refused to accept because it would have removed the company's ability to prohibit the use of its models for autonomous weapons and mass surveillance. Defense Secretary Hegseth publicly accused Anthropic of delivering a master class in arrogance and betrayal and of attempting to seize veto power over the operational decisions of the United States military. The same designation historically reserved for foreign adversaries like Huawei and ZTE was applied to an American company for the first time. One report described the result as a de facto licensing regime, and there is no guarantee of continued approval. As one analyst put it directly, you have no idea whether the United States government is just going to shut off your access to any future models. The controls were partially lifted on June 30th. After Anthropic agreed to significantly strengthen the model's safety guardrails, a move that, according to one report, caused a collapse in the model's benchmark scores, demonstrating lower overall intelligence and capacity. In other words, to get the models back online, Anthropic made them less capable. The government had effectively imposed a ceiling on what the technology was permitted to be. The parallel to the crypto wars is not a metaphor. It is the same legal architecture. The Arms Export Control Act, the Bureau of Industry and Security, the same framework that tried to classify Phil Zimmermann's privacy software as a munition in 1993 is the framework being used to classify AI model outputs in 2026. The question the crypto wars eventually forced the government to answer was a simple one. If a technology is already widely available, if it exists in the open, if it cannot be contained, what does restricting it actually accomplish? The government's answer in the 1990s was nothing. They lost. The controls collapsed. PGP spread to every corner of the world. The question being forced again in 2026 is the same question. China has frontier AI models. Russia has frontier AI models. The capabilities Anthropic was ordered to suppress are not uniquely American.
Government overreach cannot contain code that has already escaped.
They are documented in published research accessible to anyone with an internet connection. What the June 12th directive accomplished was not the containment of a dangerous capability. It was the demonstration that one government agency can shut down a global technology platform in 90 minutes. Without a court order, without public comment, without a mechanism for the hundreds of millions of people affected to appeal, and without certainty that the legal basis for the directive was sound.
This risk label is entirely unjustified.
Legal analysts reviewing the order noted that the mechanism used to issue it is normally reserved for specific transactions to specific countries, not a blanket global suspension of access by nationality. The legal backing, as one scholar put it, seems uncertain. The crypto wars ended with a clear verdict. The government overreached. The technology was too distributed to contain. The legal framework was too blunt for the reality of how software spreads. And the attempt to control encryption nearly imprisoned a man whose software helped save civilian lives in Kosovo. The AI export control fight is not over. Anthropic is currently in active litigation with the Pentagon over its designation as a supply chain risk. OpenAI, watching what happened to Anthropic, agreed to limit the release of its own frontier model, GPT 5.6, without being asked twice. The chilling effect is already visible, and beneath all of it, a question that the crypto wars never fully resolved. When a government classifies a technology as a weapon, who decides what counts as a weapon? Who decides when the classification is accurate? And who decides what happens to the people caught in the middle when the answer turns out to be wrong? Phil Zimmermann spent 3 years under federal investigation for writing software that protected human rights. The investigation was closed. The controls were abandoned. The technology spread anyway. And 30 years later, the same argument is being made about a different technology by the same government, using the same law. And as always, this is Ghost in the BIOS. And until next time, stay human.